from the president on down when they make a decision disagreeing with them?
I mean, the number I can think of is 5, Senator, but that's, there's probably more. That's just what has been widely reported. And I think, it's worth stressing that the point, including the president, and it's worth stressing that the point is Stephen Miller, the Attorney General, the Deputy Attorney General, the then Chief of Staff of the Justice Department, Chad Mizell. And I think it's worth stressing that the point here is not that it is never appropriate for the executive branch to raise concerns about federal judges. The point is that there are processes for those concerns. And so I'm just struck that here we are, more than an hour into the hearing, and this is going to be the first mention of the Judicial Conduct and Disability Act of 1980, which Congress passed largely to recognize the fact that it was a impossible choice to have nothing or impeachment as the options for.
What started as a technical debate over court procedures quickly became one of the most consequential moments of the hearing, as Senator Sheldon Whitehouse of Rhode Island directly challenged claims made by Senator Ted Cruz, calling them inaccurate and misleading, and then laid out a much larger warning about threats to judicial independence. If you value reporting that explains what these clashes actually mean for democracy, make sure you subscribe.
With respect to the let me just summarize the Administrative Office of the Court's order, because some of the things that the chairman have said are not quite accurate. First of all, it was standard operating procedure not to disclose the names associated with toll records when the toll records were sought by the government under DOJ's, both Democrat and Republican. In fact, it was the Trump 1 DOJ that did this with respect to House members. And it was the Biden DOJ that fixed this problem to require that the disclosure now be made. And the suggestion that the basis for the need for a non-disclosure order would be the conduct of the recipient of the person whose toll records were obtained has been fairly well rebutted by Jack Smith in his sworn testimony in the House, where he pointed out that the basis for that order was the pattern and practice of Trump associates putting improper pressure to bear to intimidate witnesses over and over and over again. The fault lay in the conspiracy, not in the subjects of the toll records request. Professor Vladeck, we've talked, I think there's a pretty good fault line here between adjudicative decisions, whose remedy is appeal, and personal or administrative misconduct that traditionally forms the basis for an impeachment. On which side of that line would the failure to declare or pay personal income taxes fall?
Yeah, I think it's certainly on the personal off-the-bench side of that, Senator.
Yeah, that would be personal misconduct of the kind that impeachment would likely cover. And we still don't know the answers to those questions, which to me is quite surprising. Is it not also true that regular citizens have been prosecuted and convicted for failing to report income and pay associated taxes?
Fairly regularly, to my understanding, Senator.
Yeah. And if we look at this question of threats, which is the context for a great deal of what we're hearing today, it appears to me, and it appears to judges who've spoken out to this effect, that there is a pattern of threat, an unprecedented pattern of threat that has arisen during this administration with, as you point out, judges who've been appointed by all presidents who have surviving appointees. And it's not just the threat that's part of it. It's also what the judges are saying about the Department of Justice and its lawyers. So back to the MAGA DOJ, just summarizing some of the words that have been used about their arguments and behavior in court: disingenuous arguments 5 times, bad faith arguments 5 times, unprecedented behavior including, quote, concerted effort by the executive to smear and impugn individual judges who rule against it, being both unprecedented and unfortunate. That's a Trump appointee speaking about this administration's behavior. Shoddy work 3 times. DOJ losing credibility or being disrespectful, having lied, willful and intentional noncompliance with orders, pretexts being offered, unconscionable arguments, nonsensical arguments. In that environment, what then comes into play is, I'll let you pick it up from here. How many senior people in the administration have made threats against judges, both generally and specifically, from the president on down, when they make a decision disagreeing with them?
I mean, the number I can think of is 5, Senator, but that's, there's probably more. That's just what has been widely reported. And I think, it's worth stressing that the point, including the president, and it's worth stressing that the point is Stephen Miller, the Attorney General, the Deputy Attorney General, the then Chief of Staff of the Justice Department, Chad Mizell. And I think it's worth stressing that the point here is not that it is never appropriate for the executive branch to raise concerns about federal judges. The point is that there are processes for those concerns. And so I'm just struck that here we are, more than an hour into the hearing, and this is going to be the first mention of the Judicial Conduct and Disability Act of 1980, which Congress passed largely to recognize the fact that it was a impossible choice to have nothing or impeachment as the options for judges misbehaving. There is a JC&D process. If there were actually serious charges to be brought against these judges, that would be the avenue. It hasn't been utilized except for the frivolous complaints against Chief Judge Boasberg.
Precisely. And I would argue that the context here is a pattern of threats against federal judges for unprecedentedly bad behavior by DOJ. When they call it out, they then have the cascade of threats fall in on them, and that it's a deliberate effort to try to intimidate the judiciary into not ruling against the Trump administration, no matter how defective the position that they take. And it's hard for me not to see this proceeding as supportive of that unfortunate effort.
Whitehouse began by calmly but firmly correcting the record. He explained that when the Department of Justice sought phone toll records in the past, it was standard operating procedure not to disclose the names tied to those records. That practice existed under both Republican and Democratic administrations. In fact, Whitehouse pointed out that the Trump-era Department of Justice used this very procedure when seeking records connected to members of Congress, and that it was later changed under the Biden administration to require greater disclosure and transparency. That distinction matters because some of the rhetoric surrounding the issue has suggested secrecy or misconduct where long-standing procedure existed. Whitehouse emphasized that the rules were not designed to shield wrongdoing by individuals whose records were obtained, but to protect investigations from interference. He then addressed another claim, the idea that non-disclosure orders were issued because of bad behavior by the person whose records were sought. Whitehouse cited sworn testimony from Special Counsel Jack Smith, who explained that these orders were issued due to a documented pattern of witness intimidation by Trump associates. In other words, the concern was not the subject of the records, but the surrounding conspiracy and its repeated efforts to pressure or threaten witnesses. That clarification reframed the issue entirely. It shifted responsibility away from individual record holders and placed it squarely on a broader pattern of conduct that courts found threatening to the integrity of investigations. If you want more reporting that cuts through oversimplified talking points, subscribe so you do not miss future breakdowns. Vladek responded unequivocally that it would. Such behavior would constitute personal misconduct, not a legal disagreement over rulings, and therefore could potentially warrant impeachment. Whitehouse noted that ordinary citizens are routinely prosecuted for failure to report income and pay taxes, underscoring the principle that judges are not above the law. What made this moment striking was not just the legal clarity, but the implication that unresolved questions remain unanswered despite their seriousness. The conversation then turned to what Whitehouse described as an unprecedented pattern of threats against federal judges. He noted that judges appointed by presidents from across the political spectrum have publicly warned about rising intimidation, something they say has escalated dramatically in recent years. Whitehouse cited language used by judges themselves to describe the conduct of Department of Justice lawyers in court. Terms like disingenuous, bad faith, shoddy work, loss of credibility, willful non-compliance with court orders, and even unconscionable arguments were not political slogans. They were phrases pulled directly from judicial opinions. One particularly striking example came from a judge appointed by Donald Trump, who criticized what he described as a concerted effort by the executive branch to smear and impugn judges who rule against it. That criticism did not come from a political opponent, but from within the president's own judicial legacy. If you want informed coverage of how institutional norms are being tested, subscribe for ongoing analysis. Whitehouse then asked how many senior administration officials have publicly attacked judges after unfavorable rulings. In Whitehouse's view, this creates a dangerous cycle. Judges identify serious flaws or misconduct by government attorneys. The administration responds not by correcting the behavior, but by escalating attacks on the judges themselves. The goal, he warned, appears to be intimidation, discouraging judges from ruling against the government regardless of how weak its legal arguments may be. Whitehouse concluded by saying it was difficult for him not to see the hearing itself as contributing to that pressure campaign. His warning was stark, that undermining judicial independence does not happen all at once, but through repeated efforts to discredit and intimidate the courts until they no longer serve as an effective check on executive power. This exchange was not just a partisan argument, it was a window into a deeper struggle over whether the rule of law remains insulated from political retaliation. That is why moments like this matter far beyond the hearing room. If you want continued coverage that explains the stakes, not just the shouting, make sure to subscribe.